Good morning. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions, as well as those joining us today on C-SPAN. Would ask you in-house if you'll be so kind to check that cell phones have been silenced as we prepare to begin. And, of course, we will post the program on the Heritage homepage for everyone's future reference following today's presentations. We also used the Preserve the Constitution series this fall as an opportunity to report again on our re-release of Heritage's Guide to the Constitution, revised after 10 years in existence. It has over 100 commentators who discuss each of the clauses of the Constitution individually. For reference, it is a wonderful work for any age to use, and we do have copies available if you would be interested. And for those on the Twitter world, we, of course, have our hashtag #OurConstitution as we continue through the day's discussion for those who want to make direct comments on the program. Hosting our discussion between our two wonderful gentlemen is John Malcolm. Mr. Malcolm serves as director of our Edwin Meese Center for Legal and Judicial Studies. Please join me in welcoming John Malcolm. John?
Thank you, John, and they are two wonderful gentlemen. Well, I want to begin by welcoming you all to the fifth in our seven-part Preserve the Constitution series, and I hope to see some of you next Wednesday at our annual Joseph Story Lecture, which is going to be delivered by the Honorable Carlos Bea of the Ninth Circuit Court of Appeals, and then at our final event on October the 30th, which is going to be a debate between Professor Randy Barnett and Justice Stephen Markman of the Michigan Supreme Court about whether the United States Supreme Court should re-examine and reinvigorate the Privileges and Immunities Clause. But today, we are going to hear a debate about a very important and timely topic. Does the Constitution of the United States guarantee citizenship to the children of illegal immigrants who are born in this country? This has become an increasingly important topic in this country, given our problems with illegal immigration. U.S. citizenship confers substantial benefits, and many think that birthright citizenship is a powerful magnet, one among many, that attracts illegal immigrants to the United States. The answer to this question is not of mere academic interest. If birthright citizenship is not guaranteed by the Constitution, then Congress could simply outlaw the practice by passing a law to that effect. And while passing a law outlawing birthright citizenship would not be an easy undertaking in today's highly politicized climate, it would certainly be much easier to do than amending the Constitution. We are fortunate to have with us today two very distinguished speakers who will now receive an introduction by me that is way too short and far shorter than each one of them deserves, but I want to make sure that we can get right to it. Our first speaker will be Jim Howe. Jim is a partner in the Dallas office of Gibson, Dunn, and Crutcher, where he leads the firm's appellate and constitutional law practice group in Texas. Jim received his undergraduate degree from Stanford University and his law degree from the University of Chicago. After graduating from law school, he clerked for Judge Jerry Smith on the Fifth Circuit Court of Appeals and then for Justice Clarence Thomas on the United States Supreme Court. Before going to Gibson Dunn, Jim had a distinguished career in government service. Among other positions, he served as chief counsel to Senator John Cornyn and the Senate Judiciary Subcommittees on the Constitution and Immigration. He also worked in the Civil Rights Division and the Office of Legal Counsel at the Department of Justice. Most recently, Jim served as the Solicitor General of Texas, where he was, and still is, considered one of the top appellate lawyers in the country, where he received 3 Supreme Court Best Brief Awards by the National Association of Attorneys General. The Texas Tribune has called Jim one of the big guns of the Texas bar, and the National Law Journal named him among the upper echelons of the Supreme Court practice and one of the top minority lawyers in the nation, although I think they could have just said he was one of the top lawyers in the nation, period. John Eastman, who will go after Jim, is the Henry Salvatore Professor of Law and Community Service at Chapman University Fowler School of Law. He is also the founding director of the Center for Constitutional Jurisprudence, which is a public interest law firm affiliated with the Claremont Institute. John received his undergraduate degree from the University of Dallas. He earned a PhD and a master's from Claremont with concentrations in political philosophy, American government, constitutional law and international relations, and he earned his law degree from the University of Chicago. After graduating from law school, John clerked for Judge Michael Ludig on the Fourth Circuit Court of Appeals, and then he too clerked for Justice Clarence Thomas on the U.S. Supreme Court. During the Reagan administration, John also served as the Director of Congressional and Public Affairs at the United States Commission on Civil Rights. And without further ado, Jim, the floor is yours.
First, pardon me if my voice starts to go out. I'm still recovering from a cold. But thank you, John, for that. What can I say about that introduction? I think it was Alan Greenspan that used the phrase irrationally exuberant. At least with respect to me, that was an irrationally exuberant introduction, but I'm honored by it, and I'm frankly privileged to be your friend. It's also, frankly, great to be back with the other John up here, Professor Eastman, another dear friend. How many times have we debated this issue? It's dozens. Yeah, it's been a lot. It's almost, given our very similar resumes, it almost seems like a family Thanksgiving where we come back every year and squabble yet again. But it's great to be back with you. I am honestly honored to be here at the Heritage Foundation to discuss the Constitution and the rule of law. And in particular, we're here today to debate one of the most, frankly, emotional issues facing our country when it comes to the Constitution and the rule of law. And that's the challenge that illegal immigration presents to the rule of law. Now, many people of good faith, I might add, are deeply concerned that birthright citizenship presents some significant challenges to the rule of law. And I'm certainly not here to quarrel with those deeply held good faith concerns. But what I am here today to do is to hopefully try to, frankly, bring at least some consensus to this discussion. For example, I hope we can all agree that if you want to change a law, you must go through the process that is set forth in our Constitution. So, for example, when President Obama issued his executive order concerning immigration, many people of good faith, again, including, frankly, the political leadership of my home state of Texas, many were deeply concerned that the president was attempting to unilaterally rewrite the law in complete circumvention of Congress and Congress's powers under the Constitution. As we all know, of course, the Constitution sets forth our process for writing the laws of the United States. It takes majorities of both houses in Congress plus the president, or alternatively, 2/3 of both houses of Congress without the president. But in no case can a president unilaterally repeal a federal statute. And likewise, the Constitution sets forth our process for amending the Constitution. It typically requires 2/3 of both houses of Congress plus ratification by 3/4 of the states. So if there is any provision of the Constitution that we might not like and we want to get rid of, we would nevertheless have to agree, I hope, that we couldn't just pass a statute to repeal it, any more than the president can issue an executive order repealing a statute that he doesn't like. So, even if you believe that birthright citizenship is profoundly wrong and should not be the law of the land, I hope that we can at least agree on the following principle. If I were able to convince you that birthright citizenship is indeed a part of our Constitution, you and I may or may not like that, but I hope that we can agree that the only way you can do something about that, the only way that you could repeal a provision of the Constitution, is to amend the Constitution. That's all I'm really asking of everybody today, because I do believe that I can convince each and every one of you that birthright citizenship is a part of the Constitution. Indeed, I sincerely don't think it's a close call. Every traditional tool of legal interpretation and constitutional analysis points in exactly the same direction. We can look at the text of the Constitution, and we will. We can look at congressional history, Supreme Court precedent, and executive branch interpretation. And they all say the same thing. They all point us in the same direction, which is that birthright citizenship applies to everyone who is born in the United States and subject to the laws of the United States. That is, everyone who is required to follow the laws of the United States. Now, just a brief history. Birthright citizenship is a centuries-old rule of the English common law, one that long pre-existed not only the 14th Amendment, but frankly, pre-existed our Constitution. Now, some people have said that birthright citizenship seems an obsolete concept in an era of easy interstate and international transportation and travel, where you were born really doesn't have the same oomph that maybe used to be. But of course, just because a provision of the Constitution might arguably be obsolete doesn't mean we can ignore it. Slavery should have been obsolete from the outset of our Constitution, but the original Constitution expressly contemplated the institution of slavery, that states would have the right to enforce and to have that institution. It is a terrible stain on our nation and our Constitution, of course, but even that took a constitutional amendment to get rid of. And so too with regard to birthright citizenship. In fact, as we'll soon see, birthright citizenship was added to the Constitution as part of our direct response to the institution of slavery. So let's begin with the text. The 14th Amendment, in the very first sentence, says, and I quote, "All persons born or naturalized in the United States and subject to the jurisdiction of the United States, subject to the jurisdiction thereof, are citizens of the United States." So it's a two-part test, if you will. If you're born in the U.S. and you're subject to the jurisdiction of the U.S., you're a citizen of the U.S. Now, we all know, of course, what it means to be born in the U.S., so the question that we're debating today is, what does it mean to be subject to the jurisdiction of the U.S.? Well, what does it mean, if we're just speaking casually, what does it mean for a government to have jurisdiction over somebody? I think it just simply means that the government has power over somebody, right? So we're talking about whether you're subject to the power of the United States, whether you're required to obey the laws of the United States. If I were to tell you that a company is subject to the jurisdiction of the FCC, what are we saying? I think all we're saying is that the company is required to obey the laws and regulations of the FCC. If I were to tell you that a person is subject to the jurisdiction of a particular court or a committee of Congress, I think what we're saying is that that person is required to obey the laws and orders of that court or of that congressional committee. Now, the phrase subject to the jurisdiction, it is in the Constitution. It has to mean something. We can't just read it out. It has to mean something, and that means essentially it has to exclude somebody from this guarantee of birthright citizenship. And it absolutely does. What it excludes are people who do not have to obey U.S. law. And the best example of this is the principle of diplomatic immunity. Foreign diplomats, people who represent a foreign nation, come to the United States on behalf of their nation. Foreign diplomats don't have to obey U.S. law. We can kick them out if they break our laws, but we can't actually enforce our laws against them because they enjoy diplomatic immunity under the long-established principle under international law. So if you're a foreign diplomat and you come here to the United States to represent your nation, and you happen to give birth to a child while you're in the United States, your child would not be subject to the jurisdiction of the U.S. They would not be required to obey U.S. law, and therefore they would not be guaranteed U.S. citizenship under the 14th Amendment. But if you're born here and you don't have any kind of immunity like diplomatic immunity, if you have to obey U.S. law, then the Constitution provides that you are a U.S. citizen. And note what doesn't matter under the text of this amendment. It doesn't matter if you don't have a good track record of complying with our laws. Indeed, it's precisely because you are subject to our laws that we can enforce these laws against you in the first place, and of course punish you if you don't obey them. It doesn't matter if your parents are citizens. Just think, it would have been so much easier for the 14th Amendment drafters to simply say, we're only giving birthright citizenship to persons born in the United States to citizens of the United States. It didn't say that. And it doesn't matter if your parents are foreign nationals who may have sworn allegiance to another country. The Constitution does not require allegiance. It requires jurisdiction. Now, usually when the text is so clear, as I would submit it as here, you could just theoretically end the analysis at that point. But the history of the 14th Amendment also happens to confirm what we read from the text. I think I noted earlier that birthright citizenship is a principle from the English common law known as jus soli. And this doctrine provided for birthright citizenship for everyone born on British soil, including those born to foreigners, with an exception under the common law for foreign diplomats. The English common law was imported, much like many aspects of English common law, imported into our country through early colonial practice, and then through early state practice. But then came along the Dred Scott case. The U.S. Supreme Court held in that case that U.S.-born children of slaves would not be entitled to this doctrine, the common law doctrine known as jus soli. Congress enacted the 14th Amendment precisely to ratify and constitutionalize the English common law doctrine of jus soli in order to overturn and overrule Dred Scott. And that's exactly what the congressional debates reflect as well. Both the sponsors and the opponents of the Citizenship Clause of the 14th Amendment agree on what the meaning of this language does. They simply disagreed on whether we should have this policy. And as I'll try to go through, the legislative history really demonstrates two fundamental understandings and insights. First, that we're extending birthright citizenship to the U.S.-born children of foreign nationals, like the Chinese, and it excludes Indian tribes due to the unique legal issues entailed by tribal sovereignty. So here's what happened in the 14th Amendment. The House passes what we now know as the 14th Amendment. It doesn't include this citizenship language. It goes over to the Senate, of course, and this is where we see this language. Senator Howard introduces it, and he explains that the purpose of his Citizenship Clause amendment is to simply declare what he believes to already be the law of the land, at least before Dred Scott, and that's the doctrine of jus soli. And he then says that birthright citizenship will not, and I quote, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers, but will include every other class of persons. Okay, so that's the sponsor of this language. Senator Cohen of Pennsylvania then stands up, and he's very upset. He opposes this language strenuously, and he opposes this amendment precisely because he despises the idea of giving citizenship to the U.S.-born children of Chinese and others who, to quote his words, who owe the U.S. no allegiance and who pretend to owe none. In response, Senator Conness of California says that he agrees with Senator Cohen that that is in fact what this language would do. It would extend birthright citizenship to the U.S.-born children of foreign nationals. He agrees with that interpretation, and he also agrees with that result. That's actually what he wants, unlike Senator Cohen, who, of course, angrily opposes it. In sum, there was a consensus in Congress about the meaning of this amendment. The debate was solely about its wisdom. Now, I mentioned that there is also a second discussion in this debate about the status of Indians and the unique tribal sovereignty issues that they present. And I think during that discussion, you do see the word allegiance, and I think there are some opponents of birthright citizenship who seize upon the word allegiance. But I don't think this language ends up really helping their cause. As Senator Trumbull explains, for example, Indian tribes, and I quote, are not subject to our jurisdiction in the sense of owing allegiance solely to the United States, for it is only those persons who come completely within our jurisdiction who are subject to our laws that we think of making citizens. So he refers to allegiance, but he also refers to being subject to our laws. And in any event, what we're talking here about, of course, is the status of Indians, not the kind of foreign nationals that is the topic of today's real debate. In addition to the constitutional text and congressional history, we also have over a century of Supreme Court precedent that largely tracks this understanding as well. The most famous case in this space is U.S. versus Wonky Mark from 1898. A child was born in the United States to Chinese nationals and was, as a court held, guaranteed birthright citizenship under the 14th Amendment. Now, this is a case involving lawful residents, not illegal aliens. That doesn't seem to be a big deal to the court, but I want to sort of make that clear that it's about lawful residents. But later Supreme Court cases do address the constitutional status of U.S.-born children of illegal aliens. Plyler versus Doe in 1982. By a 5-4 vote, the Supreme Court holds that my home state of Texas could not deprive free public education to undocumented children. But although the court split 5-4 on that specific issue of public education, all 9 justices agreed with the basic principle that the Equal Protection Clause of the 14th Amendment protects legal and illegal aliens alike. And this is very important because the Equal Protection Clause contains some very similar language. It applies to persons within the jurisdiction of a state. The majority in Plyler invokes the Wonky Mark case explicitly to say that persons who have entered the United States illegally are within the jurisdiction of a state if they are present within the state's boundaries and subject to its laws. And the dissent agrees with that specific principle, expressing, quote, no quarrel with the notion that, quote, the 14th Amendment applies to aliens who, after their illegal entry into this country, are indeed physically under the jurisdiction, within the jurisdiction of a state. In addition, in INS versus Rios Pineda, a 1985 case, the Supreme Court unanimously notes, as an aside, but does note this, that an illegal alien who had given birth to a child who, born in the United States, was, quote, a citizen of this country. And finally, in Hamdi versus Rumsfeld in 2004, the plurality observed that Taliban fighter Yasser Hamdi was born in Louisiana and thus an American citizen, despite objections by various amici that at the time that he was born in the U.S., his parents were aliens in the U.S. under temporary work visas. Now, I know that there are opponents of birthright citizenship who claim that there's contrary language in 2 cases, 2 earlier cases, Slaughterhouse and Elk versus Wilkins. Now, I'll confess, Slaughterhouse does have some contrary language. It's basically a single sentence, and it occurs in a case that doesn't involve these issues at all. Moreover, Slaughterhouse doesn't provide any backup. It doesn't actually argue the issue. It doesn't cite any authority. And the Supreme Court, of course, points this out later in Wonky Mark. I'm even less concerned about the Elk versus Wilkins case. That's a case about the unique status of Indian tribes. And it was written by the same justice who later wrote Wonky Mark, Justice Horace Gray. So Justice Gray, you have basically your choice of 2 theories. Either he's being schizophrenic, or in fact, he's just reflecting the same dichotomy that we see in the congressional debates. Foreign nationals are covered, Indian tribes are not. Finally, birthright citizenship has been the consistent position of the executive branch. Since we're here at the Heritage Foundation, I will focus on just one example, what the Reagan administration said on this issue, and in particular what the Reagan administration told the U.S. Supreme Court. In a brief signed by, I think what everybody would agree are 2 of the most noted conservatives to have served in the Reagan Justice Department, and that's Solicitor General Rex Lee, father of U.S. Senator Mike Lee, and Assistant Attorney General William Bradford Reynolds. The Reagan administration said, and I quote, all aliens, even those whose presence in the country is unlawful, are persons protected by the due process clauses of the 14th and 5th Amendments. No reason appears why the term person in the Equal Protection Clause should not be given the same all-embracing construction, encompassing aliens who are unlawfully present in the United States. This conclusion is not altered by the fact that the clause refers to any person within the state's jurisdiction. The phrase within its jurisdiction was intended simply to define the class of persons guaranteed the equal protection of a state's laws to consist of all persons who are subject to those laws. I'll conclude where I began. Many Americans have sincere objections to illegal immigration and sincere concerns about the challenges it presents to the rule of law, and frankly, so do I. But there are many tools available to combat illegal immigration. Surely we can do so without offending the Constitution and the rule of law ourselves. Thank you.
Thank you all. Thanks particularly to Jim Howe for taking this issue on, and to the Heritage Foundation for hosting us on this important debate. I want to start with the points of agreement. Jim and I both went to the University of Chicago. We both clerked for Clarence Thomas. We both take seriously the notion that the original intent of the Constitution is what ought to govern these questions. Where we disagree here, and disagree rather strongly, is what the original intent of that clause meant. Now, I thought it was very telling that Jim, in his first description of this, said all persons born here and subject to our laws are citizens. And it's that kind of change in the language that I think is indicative of what the dispute is about. He then later went back to the actual language, and where it says subject to the jurisdiction, not subject to the laws. He claims that the text, the history, Supreme Court precedent, and executive branch consistent position all support the notion that subject to the jurisdiction is synonymous with subject to the laws, and that the only people intended to be excluded from that second element of the citizenship guarantee are those who are children of ambassadors. I would add, because he didn't mention it, but children of invading armies on the territory. There's one other category that Joseph Story in the English case says, children born on a ship while docked in U.S. port. And so the question for us is that's all the Citizenship Clause was intended to convey. Now, on every one of these points, text, history, precedent, and executive branch position, I think the argument is exactly the opposite of what Jim has laid out. And let me walk through this. See, because for the people that drafted the 14th Amendment, and for those that ratified it, there was agreement. And that is that subject to the jurisdiction at the time had two different meanings. What they called partial or territorial jurisdiction, that is synonymous with subject to our laws. And the other thing, what they called complete or allegiance-owing jurisdiction, something more profound than just being present within our borders and therefore subject to our laws while you're here. And the question is then, which of those two meanings did the drafters of the 14th Amendment intend to codify as the constitutional floor for automatic citizenship? And I think you can't read the debates to think anything other than that they intended to codify only that complete allegiance-owing jurisdiction, not the mere territorial one. And so let's go back a little bit of the history. Where does the debate over the Citizenship Clause come from? Well, the whole point of the 14th Amendment was to constitutionalize the 1866 Civil Rights Act. They wanted to do that for one of two reasons, probably a little bit of both. Some were concerned that the 1866 Civil Rights Act may have extended beyond Congress's powers under the 13th Amendment, and they wanted to put it on solid constitutional footing. The second is, even if it was a valid exercise of the lawmaking power Congress already had, they wanted to lock it into the Constitution so that future Congresses couldn't change it. And this is true of the entire 1866 Civil Rights Act, including the Citizenship Clause. Now, here's what the Citizenship Clause in the 1866 Act says. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. Now, under that formulation, I think it's manifestly clear that somebody who was born here, but who was also subject to a foreign power through their parent, who had continued allegiance to that foreign power, or to use the language in the 14th Amendment debates or the 66 Civil Rights Act debates themselves, those who were mere temporary sojourners here, or to put that language in modern terms, those who were here on a tourist visa or a temporary work visa. And certainly those who were not lawfully present at all, although they didn't confront that issue because we didn't have restrictions on immigrations at the time. But if you were subject to a foreign power and owed your allegiance someplace else, mere birth of your children on U.S. soil under the 66 Act was clearly not a guarantee of automatic citizenship. You continued to owe your allegiance to the nation of your parents' allegiance, not subject to any foreign power. Now, you might say, well, the Constitution language is different. Not subject to any foreign power is different than subject to the jurisdiction thereof. And maybe they intended to offer a broader grant of citizenship with the 14th Amendment. There is absolutely nothing in the debates of the 14th Amendment to suggest that that's what they were doing. Rather, what they were confronting with that change in language is the peculiar problem of Indians who, while separate sovereigns, were not foreign sovereigns. They were domestic sovereigns. And so part of the discussion and the change of that language is to reconcile the language with the existing facts on the ground with that peculiar circumstance. But it was not intended to waive the notion that this complete allegiance was still what was required, subject to the jurisdiction, not merely subject to our territorial laws while you were here. To put it in context, let me give a modern example. Suppose you're a tourist from Great Britain. In Great Britain, they have this crazy idea of driving on the left side of the road rather than the right side of the road. When they come here, they have to follow our law and drive on the right side of the road. They're subject to our jurisdiction in that partial or territorial sense. But they're not subject to the allegiance by being here on a tourist visa or a guest worker visa. They can't be prosecuted for treason. They can't be drafted into our armies. They don't have any of that more complete jurisdiction that comes from this understanding. Okay, so, and the debates, I think, in the 14th Amendment confirm this. Now, we don't have a debate specifically, and I think I'll agree with Jim, or Jim will agree with me on this, that because we didn't have any illegal immigrant, we didn't have any restrictions on immigration, they did not confront the precise issue that we're looking at today. So we're both trying to extrapolate the principles from the debates they did have. And the only debate they had about this was whether Indians would be automatic citizens. And they were deemed not to be automatic citizens, not because they were born in a foreign territory, but because they were born to a foreign, domestic, different sovereign, and owed allegiance to that sovereign, not to the United States. And that's particularly interesting because, in fact, many of the tribes by that time, through the tribe, owed allegiance to the tribe, but the tribe itself was kind of a domestic dependent of the United States, so there was an indirect allegiance to the United States, and still that wasn't sufficient. And so Senator Howard and Senator Trumbull, the two leading sponsors of the bill, and Senator Howard, the actual author of this precise language, were asked this very thing, when pressed whether Indians living on reservations would be covered, since, quote, they were most clearly subject to our jurisdiction, both civil and military. And in that sense, the question is kind of relying on this subject to our territorial jurisdiction idea. Here's how Trumbull responded. Subject to the jurisdiction means subject to its complete jurisdiction, not owing allegiance to anyone else. And to borrow the language that Jim relied on from Senator Howard, who introduced this clause, he said it means the full and complete jurisdiction. The same jurisdiction and extent and quality as applies to every citizen of the United States now. Now, that was under the 1866 Act, which said, not owing allegiance to any foreign power. That's what he is saying it's the same thing was. And so an amendment by Senator Doolittle of Wisconsin to specifically exclude Indians not taxed was rejected as redundant because this idea of complete jurisdiction, of allegiance-owing jurisdiction, was already reflected in the subject to the jurisdiction clause. Now, this was immediately recognized in the first time the Supreme Court looked at the issue in the slaughterhouse cases, which Jim did, to his credit, acknowledge. And to my credit, I hope I'll acknowledge that it was dicta. But it was clear that it says subject to the jurisdiction was intended to exclude from its operation children of ministers, councils, those are the piece that Jim says is all it does. And then it went on and said, and citizens of, or subjects of foreign states born within the United States. Close quote. All of the justices, both in the majority and dissent, agreed with that proposition. That becomes holding in the Wonky Mark case. And I don't think the question of Indians is a thing we can just cabin off to the side. It goes to the heart of the principle they are trying to address. And the principle was, if you don't owe allegiance directly to the United States, but owe it to some other sovereign, a domestic sovereign in the case of the Indians, or a foreign sovereign in the case of temporary sojourners, then you are not guaranteed automatic citizenship by virtue of the language of the 14th Amendment. And the Ilk versus Wilkins case addresses that and reaches that holding in the precise context of Indians, but the language they use, the principle they adopt, applies elsewhere. Now, this is not just the Supreme Court in the early days. Thomas Cooley, who I think everyone rightly recognizes as the leading constitutional treatise writer of the day, the leading expert on interpretation of the 14th Amendment. In his treatise, published in the 1870s, he says exactly the same thing. Subject to the jurisdiction means full and complete jurisdiction to which citizens are subject, and not any qualified and partial jurisdiction, such as may consist with allegiance to some other government. right? And he's not limiting that to the other government being the Indian tribe. It's broad, any other government. And so if you're a temporary sojourner here, certainly if you were here illegally, to bring it to the modern context, you don't have this right to automatic citizenship guaranteed by the 14th Amendment. Congress is certainly free to extend an offer of citizenship beyond that under its power of naturalization, but there's nothing in the Constitution that requires it. Now, Jim also says this is the consistent view of the executive branch. And I'll take issue with his treatment of the brief filed in the Reagan administration by Rex Lee and Brad Reynolds. They're talking about the Due Process Clause, just as Plyler versus Doe, the Supreme Court is talking about the Equal Protection Clause. Both of those clauses use the word persons, as distinguished from the Privilege and Immunities Clause, which uses the word citizens. And they don't use the phrase subject to the jurisdiction, which, as I've just described, conveys this broader, complete allegiance-owing jurisdiction. They use the phrase within the jurisdiction, which is quite clearly a territorial aspect. And so the notion that persons within the jurisdiction are subject to our laws is dramatically different than persons subject to our jurisdiction becoming automatic citizens. Any event, here's what the Attorney General in 1873 had to say in an official U.S. Attorney General opinion, Attorney General Williams. Section 1 of the 14th Amendment declares that all persons born and subject to the jurisdiction are citizens. But the word jurisdiction must be understood to mean absolute or complete jurisdiction, such as the United States had over its citizens before the adoption of this amendment. Aliens, among whom are persons born here and naturalized abroad, dwelling or being in this country, are subject to the jurisdiction of the United States only to a limited extent. Political and military rights and duties do not pertain to them, and therefore the 14th Amendment does not confer automatic citizenship on their children. Now, Jim's absolutely right that the Supreme Court in 1898 in the Wonky Mark case says that the children of Chinese immigrants were automatic citizens. Now, and the language it uses is this adoption of the very broad English common law rule of jus soli, that whenever you're born on the king's soil, you are automatically the king's subject forever, perpetual, and it could never be renounced. Now, there are a couple of things that I think we can all agree on. We fundamentally reject that doctrine in our Declaration of Independence. In fact, it is one of the most eloquent rejections of that doctrine ever penned in human history. This people separated our ties and renounced our allegiance to our prior connections. We could not have done that if the doctrine of jus soli, as conveyed to us by the English common law, remained in place, because it was perpetual allegiance. Once the king's subject, you could never renounce your allegiance. You owed perpetual duty. In fact, this fight over who owed perpetual duty or not actually gives rise not just to that original war against Great Britain, but the 1812 war as well, because the English Navy continued to recognize our sailors as still British subjects when they were on the high seas and would press them into service. We reject that notion in the Declaration of Independence. Now, Wonky Mark, the majority opinion, relies on that for its holding. But the broad dicta about adoption, that rule of jus soli, has to be treated as dicta, because the actual facts of the case involve somebody who was here lawfully and permanently, who the court goes out of its way to describe as lawfully domiciled within the United States. The only reason that those parents of Wonky Mark were not U.S. citizens is because we had entered into, quite frankly, a nefarious treaty with the Emperor of China that refused to recognize the right of them to renounce their allegiance to the old emperor, the very thing we claimed as a natural right in the Declaration of Independence. And so in those circumstances, a child born to lawful, permanent, legally domiciled residents of the United States who had done everything they could to manifest their intention of taking up their new allegiance, that we would allow them to manifest, that child was treated as a citizen of the United States. Its holding is therefore very narrow. The language, the dicta, is much broader. All right? So now, if the dicta turns out to be true from 1898, one would expect that a lot of children born in the United States Past that point were deemed automatic citizens. And in fact, that's not true for about 3/4 of a century. So think about if Wonky Mark is to actually say anybody born on U.S. soil, no matter what the circumstances, then that holding would have applied to Indians. And yet Native Americans born on U.S. soil, in fact born not off the reservation, were continued to be treated as non-citizens all the way until the 1920s and the Indian Civil Rights Act and Citizenship Act. In the 1920s, there was a massive guest worker program, largely from Mexico, but other countries in Latin America. When the Great Depression hit, many of those people were returned. There's a new documentary film out a couple years ago talking about the repatriation. Anywhere between 1.2 and 2 million Mexican guest workers were returned to Mexico. And between 400 and 500,000 children who had been born while they were here were returned as well. To my knowledge, there was not a single claim made in the 1930s, while that process was going on, that those children were citizens and therefore couldn't be returned. The same thing is true in the 1950s and 1960s Braceros program, a massive guest worker program, which when it ended, there were a lot of children that had been born on U.S. soil during the course of that program. Nobody raised the claim that they were citizens. So when did this idea that citizenship flows automatically from mere birth on U.S. soil, no matter what the circumstances of the parents, whether they were here temporarily on tourist or student or guest worker visas, and certainly whether they were illegally. So one other example, 1938, the official documents for passport that the United States State Department put out, you had to be a citizen, and on the form you had to say what city and state you were born in. This is for people born in the United States. But in order to be deemed citizen, you also had to prove the allegiance of the parents. That was a separate item on the passport application. Completely unnecessary if the mere birth was all that was required. Well, when did that change? In a regulation in 1966, the year after the 1965 Immigration Act. Right? And I can just imagine how it happened. Well, we've got this language. How do we put that? Well, we don't need that anymore because subject to the jurisdiction means just subject to our laws, so birth is all you need. And just some bureaucratic convenience thing changed the rule. It was never that way before. Okay? Now, so let me close with this, kind of the final thing. I think we can both agree that the precise question, whether the children of illegal immigrants are entitled to automatic citizenship, was not confronted by the Congress in 1868 when they were debating the language of the 14th Amendment. It was not on the horizon because at the time immigration was unfettered and encouraged, right? And so the question is, which of the better principles, which view is supported by the principles that they did articulate? But let me shift it, because I don't even think that matters. If it was not addressed, if it was not clear that the Constitution mandated citizenship for the children of illegal immigrants, the notion that we are taking away such a profound policy judgment power from Congress by silence, without anybody actually saying this is what we're intending to do, without anybody ever ratifying that view that that's what we are intending to do, it seems to me a rather dramatic change in our understanding of Constitution's restrictions on Congress, which otherwise we've recognized has plenary power to decide who are going to be citizens of this country and who are not. So I think the silence on the precise issue actually cuts strongly in my direction. Now let me close just with one last piece, and this is this extraordinary exchange between Senators Cohen and Conness that Jim relied on. Senator Cohen said, what you're going to do here is give citizenship to the Gypsies and the Chinese, right? And he says, you're going to treat them better than we treat mere sojourners, right? So implicit in his question is this distinction I'm already drawing. And Senator Conness said, I fail to even see the relevance of your question to the language we're proposing in the 14th Amendment. Why? Because both Gypsies and Chinese that he was talking about were here lawfully and permanently, right? And so the question that Conness responds to is, you're going to give citizenship to people who are not white Europeans. And he said, that's not what we're doing. Anybody who is here lawfully, permanently, who owes allegiance to the United States. And the allegiance language Jim cited was just referring to the Gypsies, who he says don't owe allegiance to anybody and they don't pay taxes and they're thieves. That's not the kind of allegiance we're talking about here. Both the Chinese and the Gypsies were here lawfully, they were here permanently, and we were not going to make race-based distinctions on who to give citizenship to. That exchange says nothing about the question of whether mere temporary sojourners, and it clearly says nothing about people who are here unlawfully in the first place, are going to be automatically entitled to citizenship by this clause. So I agree with Jim that the text, the history, Supreme Court precedent, and executive branch rulings ought to help inform our understanding of this. But contrary to him, every one of them cuts in the direction of saying subject to the jurisdiction means subject to the complete and allegiance-owing jurisdiction, not this thing called mere partial or territorial jurisdiction as applied to temporary sojourners in the United States. Thank you all very much.
I want to make sure that we have time to get to at least a couple of questions, but I thought I would so start formulating your questions, but I want to give Jim just a moment to respond to any points that John just made that he would like
Or
responding
if
to.
time's up, I'm happy to.
Well, okay, then we can go to questions. I would say this. When you're recognized, we'll hand you a microphone. Please state who you are, any affiliation that you might have, and I would ask that you keep your question short and end it with a question mark. All right. Yes, let's go right over here.
Thank you. I'm Dino Drudy. I'm on the Federation for American Immigration Reform Board of Advisors, speaking for myself, not the organization. And I guess the question that I have devolves to how our jurisprudence is actually done, which is who has 5 votes on the Supreme Court. And that, it's like a shake and bake chicken. Well, it's a little bit of the original intent and a little bit of what the rules actually say, and did they really mean that, and what's the practice now? And so I'd like the 2 speakers to address the question of why they think their view is likely to get 5 votes. There's the question mark. Yeah. Because there are 2 things that they didn't address, which the amendment might have been trying to get, the 14th Amendment might have been trying to get at. One is the Dred Scott decision, which said slaves could never be. So therefore, there had to be an amendment to get around Dred Scott. And the other one...
Yeah.
Keep it short. Go ahead.
The other one is the way our laws tend to evolve. Has the Supreme Court, by mandating that the children of illegal immigrants have the right to an education, effectively backed into an implicit interpretation of the 14th Amendment? Second question.
So good. So let me take each of these up. I'd be surprised unless Congress weighed in as well with its understanding that the 14th Amendment didn't curtail its naturalization powers beyond the floor of overturning Dred Scott and the children of people who are here lawfully and permanently. Congress doesn't weigh in, and the court's likely not going to adopt my view of the 14th Amendment. There's a kind of inertia that's built up at least for 50 years. But I reject the notion that it's already decided this question. And I think Jim will agree with me on this, that what the language in Plyler versus Doe, an opinion by Justice Brennan, not exactly the greatest devotee to originalism that's ever served on the court. And it's not even a really sustained argument in the opinion itself. It's a little footnote. It's not a case that dealt with the Citizenship Clause. He was making a comparison to the Citizenship Clause and his erroneous understanding of it in a footnote to prove what persons within the jurisdiction in the Equal Protection Clause meant. And as I described, those are radically different. The same thing is true in the INS case. So they haven't settled this, and I think they've recognized they haven't settled it. And the question is, when they are confronted with it, where will they go? And if Congress stays silent or acquiesces in this notion that anybody born on U.S. soil is all you need, then they may well say that that's what the Constitution requires. But if Congress has weighed in vigorously, and there are several bills and have been several bills introduced all the way back to the 1990s that attempt to clarify their understanding of the floor that the Constitution mandates, then I think the court would be much more likely to take that into account, and there may, as a result, be 5 votes to go my way.
So I agree that the issue has not been formally decided by the Supreme Court, and I agree that Justice Brennan is not an originalist. So we'll start there. I think where we disagree, though, is I do think that cases like Plyler and other cases and other authorities establish a principle, establish a clear principle that Supreme Court justices seem to have consensus on and other authorities seem to have consensus on. What is the rule that we're establishing? So you have a rule in the Constitution, and you have a fact pattern that has not yet been presented to the court. But you still have a rule. And I'll use this as an opportunity to deal with, I think, some of the discussion about whether Plyler and the Reagan administration brief has anything to say on this. I think you drew two contrasts. One was that you said Plyler is about the Equal Protection Clause, not about the Citizenship Clause. True. And you drew two textual distinctions between the Equal Protection Clause and the Citizenship Clause. One, you said equal protection says persons, whereas the P&I Clause, the Privileges and Immunities Clause, says citizens. But of course, we're not talking about the P&I Clause. We're talking about the Citizenship Clause, and the Citizenship Clause says all persons. I think your main point, though, was the Equal Protection Clause uses the phrase, so in other words, if you don't understand, if he's saying that it matters that it's the word persons rather than citizens, well, that favors me because the Citizenship Clause refers to persons. I don't think that's his real point, though. I think his real point is that equal protection uses the phrase within the jurisdiction of a state, whereas the Citizenship Clause admittedly uses different language. It says subject to the jurisdiction, so subject rather than within. But my only point there, and I think I addressed it, is all these authorities, the Plyler case, the Reagan administration brief in the Plyler case, all use these terms interchangeably. I think I read them earlier, so I don't want to bore you with them, but it says when you look at within jurisdiction, when you look at the Equal Protection Clause, it's focusing on those people who are subject to our laws. So I think everybody's using the language interchangeably.
Next, let's go over here.
Give her the other one.
So, my question.
Hang on, wait for the
Go
other one.
ahead.
Because they're recording. They're doing can you get it over there?
Excuse me.
I think they're recording this for posterity.
And I particularly want to hear what the Senate Judiciary Committee thinks about it.
I am not here on behalf of the Senate Judiciary.
Somebody with real power is here to talk.
So my question is for Professor Eastman. What I understood to be your account of the distinction drawn in the Constitution, this sort of strong form jurisdiction that includes allegiance, doesn't seem to me to turn very much at all on whether someone is legally here in the country or illegally here. And you yourself talked about temporary guest workers and folks like that who are here legally, but who shouldn't be included. But the distinction you draw, or the way that you contrast the Wonky Mark case, sounded to me like you were relying very much on that distinction, whether someone was a legal or illegal immigrant. When you discussed how we know whether someone meets this allegiance jurisdiction test, you kept using the phrase lawful and permanent, and I immediately thought of lawful permanent residents who are not citizens of the United States, cannot vote, well, I guess they may serve in the military, but they cannot vote. And I wonder how you reconcile your position on Wonky Mark and the distinction you've drawn between legal and illegal immigrants and how they're treated, and your more general position on what the clause means.
Yeah, so a very good question. Thank you. I think it's arguable that Wonky Mark, under the original understanding, is wrongly decided. But I also think that there is a credible argument to be made that on its narrow holding, it is rightly decided. And that is because we refuse to recognize the ability of the Chinese immigrants to renounce their prior allegiance. And that is a rejection of our own theory of our Declaration. We refuse to recognize for them the very thing we claimed as a human right entitlement in our Declaration. And so if you look at the broader principle that kind of underlines our very regime, the notion that they had taken as many steps as we would have allowed to demonstrate allegiance and permanent affiliation with this country. Makes them kind of different than people who are here merely temporarily on a student visa or a tourist visa or a guest worker visa, and certainly different than people who are here illegally without any consent whatsoever to being here. And so if I want to accept the holding of Wonky Mark as far as that goes, I can do that quite coherently, I think. But all of the rest of it that flows from the dicta in Wonky Mark undercuts the very notion of consent. I've consented to let you here come visit till you can see the Statue of Liberty in New York, and that means I've consented to make you part of our body politic. Those two things don't necessarily follow. And if I've never consented to have you here in the first place, that's the category of folks who are here illegally or who have overstayed their temporary visitor status, then the notion of consent as the basis of citizenship, which is what our Declaration clearly sets out, and instead, this old feudal notion of you're born on the soil, you are forever our subject, and we owe you the response in kind, we have turned upside down the very principle that we established in the Declaration. And so I'm willing to accept the holding in Wonky Mark and try and draw the line a little bit further than I think the 14th Amendment's drafters actually did because of that unique circumstance. But all of that other dicta throws off so much of the theory of our American founding that I can't accept it.
If I may, yeah. I think it's a great question because it isolates exactly what Professor Eastman is arguing. He is making what I might call the true substantive distinction he's drawing is between people who have allegiance and people who don't. It's all about allegiance. We heard that a lot today. And I think that's because that's his argument. Which means that his distinction is between, exactly as the questioner said, between U.S. citizens and non-citizens. Right? That's the substantive distinction that's being drawn. He's also making a strategic distinction between legal and illegal, but that's just, I think, your basic way of slicing and dicing some precedent. Your core, the argument that you're drawing from principle is foreigner versus citizen. Okay, so on that point, I think what we heard today was an acknowledgement, I would say an admission, that there are two different ways of construing the term jurisdiction in the 14th Amendment. Under one way, I'm right. Under one way, he's right. Okay, so there's at least an acknowledgement that there are reasonable, I suppose, interpretations on both sides. If we were to agree that the word jurisdiction is ambiguous, that we don't know, based on the text alone, what the framers meant, this is the classic situation where lawyers and jurists go to legislative history. And when you look at the debates, we have a very clear debate, as I've alluded to before. The whole point of Senator Cohen's very fiery, angry retort is that he did not want foreigners to be citizens. That was the whole point. And by the way, I'll mention, the 1866 Civil Rights Act was invoked. We had the exact same debate in that context. So I will grant you that the foreign powers language in the 1866 Act may arguably be construed in a different way. Maybe that's ambiguous. But once again, the debate in the 66 Civil Rights Act was people who hated the language precisely because they did not want U.S.-born children of foreign nationals to have status. Finally, with respect to the Declaration of Independence point, and the fact that the Declaration of Independence rejected the English common law doctrine of, in terms of feudalism and all that, I don't see why that bears upon this discussion. Yes, in America, we do not have a tradition of mandatory allegiance. Unlike Britain, where you were not allowed to renounce your British citizenship, we have a notion that if you want to, you can renounce your U.S. citizen and become a citizen of another country. In other words, all we're talking about is exit rights. This debate, however, is about entry rights, about becoming a citizen. So I'm not really sure how one has anything to do with the other.
Here's how they tie. They're both grounded on consent rather than the old feudal doctrine. The ability to renounce your allegiance doesn't give you the right to demand allegiance or demand participation in another body politic. You only get that if they agree. It's a bilateral consent. And the problem with mandatory birthright citizenship, as it's lately been interpreted, is that you've got a lot of people here for whom we don't even consent to be here, much less consent to become part of the body politic and citizens, who are demanding that right, which throws the notion of consent as the basis for the body politic under the bus. I mean, that's the connection between the two. And you can't divorce the right of of exit from the right of entry if you're going to either have both based on consent or neither based on consent. You can't mix those two. And what the Birthright Citizenship command is, people are demanding automatic entitled to citizenship without any claim of consent of the body politic. That's the difference.
I'll just briefly,
Yeah, and then
again,
we'll take one more
again, though, I feel like we're shifting because we do, under the consent regime, we're talking about illegal. We do consent to foreign nationals legally coming in, and yet your argument, I mean, those
that's
people
right.
would not have allegiance, they would still be excluded.
That's
under
right,
theory.
but we're consenting to them being temporarily here. We're not consenting to them becoming part of the body politic. They are mere temporary sojourners, subject to our territorial jurisdiction while they're here, but not subject to the more complete jurisdiction. So it's perfectly consistent. To draw the line between those who are lawfully permanently domiciled here, that's Wonky Mark, those who are lawfully temporarily here, and those who are not here lawfully at all.
But in both cases, we're talking about people who don't have allegiance, they're foreign nationals.
Well-
And I think you said you wanted to throw
No,
out
no,
all-
but Joseph Story even says at some point, he says that this notion of allegiance is kind of a continuum. The final end point of it is citizenship, but somebody who has taken up lawful permanent residence is manifesting a degree of allegiance that's dramatically different than any allegiance that's owed by people who are temporary here, whose only allegiance is to comply with the laws while they're here, but not anything to the body politic.
Okay, let's take one, we have time for one more question, let's come right down here. Just coming here.
Thank you. Peggy Orchowski. I'm a congressional reporter for the Hispanic Outlook, and I'm sorry I'm late, but you're right on the questions. I was wondering about what does subject to the jurisdiction mean, allegiance or subject to the laws. And we won't even get into bi-citizenship, dual citizenship. I mean, where does allegiance come in on that when people have two citizenships? But my question is, what's happening now with the illegal community is that they are being now waived from many laws. And so how does subject to the jurisdiction of the laws pass for the right to birthright citizenship when they are now being waived from labor laws, immigration laws, deportation, just about any law that would require them to be punished, they are now being waived from. So how do they get birthright citizenship when they
When they're
are
not
really
even subject to the laws
subject
itself,
to a lot of
yeah.
our laws? Yeah.
Let me take first step, because I think Jim will agree with me on this. One of the more silly arguments that I think has been made is that if you're right about subject to their jurisdiction, then we can't even prosecute illegal immigrants for coming here illegally because they're not subject to our laws. And I think Jim will agree with me that if there are in fact two different understandings of subject to the jurisdiction, subject to the laws and subject to this more complete, I still get to prosecute you for violating our laws even if I don't accept that you're subject to the more complete jurisdiction. Your question goes at it from the other end. If we're waiving their compliance with even all the laws, even under Jim's version of subject to the jurisdiction, they're not entitled to birthright citizenship. So that I'll pass over to you.
Yeah, look, yes, absolutely. If the 14th Amendment said only the children of only the U.S.-born children of citizens are entitled to birthright citizenship, yes, we can still enforce our immigration laws. The two have nothing to do with each other.
Well, this has been a great debate. I want to thank you both for being here. Please join me in thanking our speakers. Thank you.